No one expected the day to end like this. The courthouse steps were quiet at first, unusually quiet for a case that had already consumed weeks of headlines, speculation, and whispered rumors inside Washington. Reporters stood in clusters, checking phones, waiting for something to happen. Then the black SUVs arrived. Not the kind used for political appearances, not the kind with waving aides or press secretaries. These were federal vehicles, and behind them came U.S. Marshals. That was the moment everything changed. Word spread through the crowd in seconds. Melania Trump was inside the building, not arriving, not leaving, already inside. And she wasn't there as a spectator. She was there to testify. For months, legal analysts had dismissed the possibility. Too dramatic, too unlikely, too politically explosive. Former first ladies don't take the stand, especially not in cases orbiting criminal exposure, until they do. Court officials later confirmed that Melania had entered through a secured underground entrance just after dawn. No cameras, no public schedule, no announcement. This was not a symbolic appearance. It was procedural, and it came with conditions. According to sources familiar with the matter, federal prosecutors had presented her attorneys with a stark choice days earlier: cooperate fully or face exposure tied to financial and disclosure violations that carried real prison risk. This was not about politics. It was about liability. By the time the marshals took their positions outside the courtroom, one thing was already clear. The wall of silence had cracked. Inside, the atmosphere was tense, not chaotic, controlled. Judges don't tolerate spectacle in moments like this. Every movement was deliberate. Every word weighed. Melania entered the room without looking toward the gallery. No expression, no visible emotion, no acknowledgement of the press. She was sworn in quietly, and for the first time since the legal storm surrounding the Trump family began, someone from the inner circle wasn't deflecting. They were answering. The testimony was sealed initially, but leaks, careful ones, began appearing within hours. Not details, signals. The cooperation was real, and it wasn't limited. Legal experts immediately understood what that meant. This wasn't damage control, it was self-preservation. To understand how the situation reached this point, you have to rewind months to a case that was never supposed to involve her. The original investigation focused on financial structures, shell companies, asset valuations, disclosure discrepancies, the kind of white-collar exposure that usually stays buried under legal motions and delays, until prosecutors noticed something: a pattern. Documents signed, accounts linked, payments authorized. Not as a passive spouse, but as a named participant in specific filings. At first, her legal team argued what many expected: ceremonial involvement. No operational role. Standard spousal inclusion. It worked for a while. Then came the emails, then the signatures, then the timing discrepancies. That's when the tone changed. Behind closed doors, prosecutors made something very clear. Ignorance would not hold, and neither would loyalty. When the deal was offered, it wasn't framed as punishment. It was framed as reality. Testify truthfully, cooperate fully, and avoid charges. Refuse and face them alone. That's the pressure point no amount of political power can erase. By mid-morning, news networks were scrambling to confirm what they were hearing. Most hesitated. This wasn't a rumor you could afford to get wrong. Then the marshals were seen repositioning. That confirmation was enough. Anchors began using careful language. Extraordinary developments, unprecedented cooperation, a former first lady under oath. Social media exploded, but the reaction inside Washington was quieter and far more serious. Because everyone understood the implication. If Melania was testifying, the case had moved past speculation. It had entered the final phase, and the reason wasn't revenge or politics, it was leverage. Sources close to the proceedings say her testimony focused on 3 areas: financial awareness, decision-making authority, and knowledge of record-keeping practices inside Trump-controlled entities. In other words, intent. That's the difference between civil exposure and criminal liability, and intent is what puts people in prison. Outside the courthouse, Trump allies attempted to downplay the significance. Routine, voluntary, nothing burger. No one inside the legal system believed that. You don't bring in marshals for routine testimony. You don't seal records for voluntary cooperation, and you don't offer immunity without expecting something in return. As the hours passed, one question dominated every private conversation in Washington. What is she giving them? Because prosecutors don't apply pressure like this unless they already have most of what they need. Testimony isn't about discovery, it's about confirmation. And once confirmation exists, timelines accelerate. By late afternoon, Melania exited the building the same way she entered, underground, unseen. No statement was issued, no denial followed. Silence, in moments like this, speaks louder than outrage. Legal analysts were already drawing the inevitable conclusion. This wasn't about saving a marriage. This wasn't about politics. This was about survival. And the presence of U.S. Marshals made one thing painfully clear. The consequences were no longer hypothetical. They were imminent. What most people didn't realize that day was this. Melania's testimony wasn't about the past. It was about the future. Inside federal investigations, testimony from someone that close doesn't exist to discover facts. It exists to lock them in. Prosecutors already knew where the paper trails led. What they needed was confirmation from someone who could not be dismissed as a political enemy or outside witness. They needed someone from inside the room, and that's why immunity was offered, not out of mercy, out of strategy. According to sources briefed on the negotiations, the immunity agreement placed in front of Melania's attorneys was narrow but powerful. It didn't cover everything. It covered specific exposure tied to financial disclosures, asset declarations, and signature authority on entities under scrutiny. In exchange, she was required to answer, fully and truthfully, questions about who made decisions, who approved structures, and who understood the legal risks at the time. That distinction matters, because once prosecutors can prove knowledge, defenses collapse. Inside the courtroom, questioning reportedly followed a calm, methodical rhythm. No theatrics, no raised voices, just documents placed on the table, one after another, signatures, dates, email threads, account movements. And the same question, repeated in different forms. Were you aware? At first, responses were cautious. I was informed. I was told. I relied on advisors. But prosecutors don't stop there. They don't accuse. They isolate. They ask again, with context, with timelines, with contradictions. That's when testimony becomes irreversible. Sources indicate the most critical moment came when prosecutors introduced a document Melania had signed during a period when the defense previously claimed she was uninvolved. The timing didn't match. The explanation didn't hold. And the silence that followed reportedly lasted longer than anyone in the room was comfortable with. That silence changed everything. Because once testimony shifts from explanation to acknowledgement, prosecutors move to the next phase: intent. Not criminal intent in the dramatic sense, but knowledge that actions carried legal risk. That's the threshold. And crossing it removes plausible deniability, not just for the witness, but for anyone whose decisions they describe. Which is why Washington reacted the way it did. This wasn't gossip, this was structural damage. By early evening, conversations inside legal circles had already moved beyond if and toward when. When indictments drop, when motions accelerate, when defenses fracture. Because cooperation from someone this close creates a domino effect. Others get nervous, others lawyer up, others consider their own exposure, and prosecutors let that pressure build. One former federal attorney put it bluntly, once someone like that testifies, the case is no longer theoretical. It's operational. Outside the courthouse, Trump's legal team issued a brief statement, carefully worded, deliberately vague. It emphasized cooperation, denied wrongdoing, and accused unnamed actors of politicization. But it avoided one thing. It did not deny the testimony. That omission did not go unnoticed. Behind the scenes, the implications were even more severe. Financial cases rely on narratives. Who controlled what? Who knew what? Who benefited? Melania's testimony didn't need to accuse anyone directly. All it had to do was map the structure. And once a structure is mapped, prosecutors fill in the rest. Late that night, sources confirmed that investigators had already scheduled follow-up sessions. Not with her, but with individuals whose names had surfaced during her testimony. That's how cooperation works. One door opens, and 10 more appear. And the Marshals? They weren't there for optics. They were there because cooperation agreements at this level are fragile. When stakes involve prison, threats escalate, from media pressure, from political allies, from individuals desperate to control damage. Federal marshals protect the process, not the narrative. The next morning, the tone across media outlets shifted. Analysts stopped speculating and started recalculating. Defense strategies that once seemed viable suddenly looked brittle. Delay tactics, jurisdictional challenges, claims of selective prosecution. None of those matter once sworn testimony aligns with documents. And alignment is exactly what prosecutors had been building toward. One detail leaked late in the evening sent shockwaves through legal circles. The testimony included clarification on who instructed legal teams on how to classify certain assets. That matters because advice of counsel defenses collapse if instructions flow the other direction. If clients guide lawyers rather than rely on them, responsibility shifts back upstream. That upstream is now exposed. For Trump allies, the reaction was panic, disguised as confidence. Public loyalty remained loud. Private concern was unmistakable. Because no matter how strong political support may be, criminal timelines do not pause for elections. They move forward, relentlessly. And Melania's testimony accelerated that clock. By cooperating, she didn't just protect herself. She reset the board. Legal experts began openly discussing scenarios once considered unthinkable. Plea negotiations, narrow indictments, superseding charges, not speculation, planning. One senior analyst summarized it this way: when someone this close testifies, the system has already decided the risk is worth it. And systems like this don't gamble lightly. As midnight passed, one question lingered in every serious conversation. What happens next? The answer was uncomfortable. Next comes confirmation. Next comes confrontation. And next comes accountability. Melania's appearance was not the end of the story. It was the signal that the story had entered its most dangerous chapter. Because once silence breaks, it never returns. And the presence of Marshals wasn't about force. It was about finality. By the time Washington woke up the next morning, one reality had settled in. This case was no longer defensive. It was advancing. Inside Trump's legal circle, strategy sessions that once focused on delay suddenly shifted tone. Lawyers don't panic publicly, but privately, adjustments were already underway. Because Melania's testimony changed the geometry of the case. Before, prosecutors were pushing uphill, forcing documents, fighting privilege claims, navigating layers of intermediaries. Now, they had something far more valuable than paper. They had narrative coherence. And in complex financial cases, coherence is everything. Sources familiar with the defense say the immediate concern wasn't what she said. It was what she confirmed. Prosecutors had long argued that decision-making authority rested at the top, not with advisors or accountants. That argument had always been hard to prove, until now. Testimony from someone embedded inside the personal and financial ecosystem doesn't need to accuse. It only needs to describe how decisions normally happened, who was consulted, who gave final approval, who questioned advice, and who didn't. That's how intent is inferred, and that's why the defense pivoted. Within hours, attorneys began signaling a new emphasis: compartmentalization. The idea that responsibilities were fragmented, that no single individual understood the full scope of actions. It's a familiar tactic, and it works, until testimony contradicts it. Prosecutors anticipated this. According to legal analysts, the questioning was designed to preempt compartmentalization claims by establishing routine involvement patterns, not exceptional moments, daily operations. Once routine is established, deniability collapses. The next pressure point was loyalty. For years, Trump's political strength relied on unwavering personal loyalty from those closest to him. That loyalty had shielded him from exposure in ways few public figures experience. But loyalty weakens under one condition: legal risk. Melania's cooperation wasn't framed as betrayal by prosecutors, and that framing matters. It was framed as necessity. Protect yourself. That message travels fast. Within days, reports emerged that multiple individuals connected to Trump-controlled entities had retained separate legal counsel. Not unusual in investigations, but the timing was telling. When cooperation begins at the top, everyone downstream reassesses. That's when cases accelerate. Behind the scenes, prosecutors were already assembling what insiders refer to as the confirmation stack, testimony that aligns across multiple witnesses, reinforcing the same operational story. Once that stack is complete, indictments become procedural, not political. Procedural indictments are the most dangerous kind because they are boring, methodical, and extremely hard to challenge. Trump's public response strategy remained aggressive. Statements dismissed the developments as manufactured and weaponized. But legal experts noticed something missing. There was no counter-narrative, no alternative explanation, no factual rebuttal, just denial. Denial works in politics. It does not work in court. Privately, advisors urged restraint. Every public statement risks contradiction. Every denial creates potential exposure if testimony diverges. Silence in this phase is often safer than outrage, and that silence grew louder. Another detail emerged late in the week that further complicated the defense. Prosecutors were reportedly examining benefit flow, who ultimately benefited from the financial arrangements under scrutiny. Benefit doesn't require authorship. It requires knowledge. And knowledge, prosecutors argue, was now easier to establish because Melania's testimony clarified household-level awareness of financial outcomes. Not technical details, but consequences. That distinction is critical. You don't need to understand tax code to understand benefit. You just need to recognize results. Once benefit is established, motive follows naturally, and motive completes the triangle. Intent, benefit, action. That's how cases survive appeals. By now, political allies had begun quietly distancing themselves, not publicly, and that would be disloyal, but tactically. Fewer appearances, more neutral language, more let the process play out statements. Those are signals. Washington understands signals. One former advisor described the mood bluntly. This stopped being a fight. It became a calculation. Calculations favor prosecutors when time is on their side, and time was now very much on their side. Grand jury activity reportedly intensified. Subpoenas expanded. Witness interviews multiplied. All of it pointed in one direction: momentum. The role of the U.S. Marshals, initially treated as a dramatic visual, was reinterpreted by experts as a sign of procedural seriousness. Not danger, but protection of cooperation integrity. When witnesses are central to a case, the system shields them aggressively. That shield doesn't come down easily. As analysts debated potential outcomes, one thing became clear. Melania's testimony had removed the most powerful defense Trump possessed: distance. He could no longer argue that inner circle knowledge was speculative. It was now documented, sworn, and corroborated. That doesn't guarantee conviction, but it guarantees exposure, and exposure changes behavior. Late Friday, reports surfaced that prosecutors were preparing for contingency indictments, filings structured to proceed even if delays or appeals arise. That's a sign of confidence. Prosecutors don't prepare contingencies unless they believe the core case is solid. By the weekend, the narrative had shifted again. This was no longer about whether something would happen. It was about scope, how wide the case would go, how many charges, how many individuals, and whether any negotiated resolutions were still possible. Because once indictments land, leverage evaporates. Melania's cooperation preserved her leverage. Others might not be so fortunate. And that reality settled heavily over Washington. The system had moved, quietly, methodically, irreversibly. And the testimony that began behind closed doors had begun to echo far beyond that courtroom. By the time legal analysts began using the phrase endgame scenarios, something important had already changed. This case was no longer speculative. It had structure. And in the American legal system, structure means inevitability. Behind closed doors, prosecutors began mapping outcomes, not asking if charges would come, but how far they would extend. When a case reaches this phase, decisions stop being emotional and start being mathematical. What can be proven? What can be corroborated? What can survive? Appeal. That's the standard. One senior legal analyst described the situation this way. Once prosecutors feel confident enough to plan multiple outcomes, it means they believe the center of gravity is secure. And that center increasingly was testimony. Melania's cooperation did something rare. It reduced uncertainty, not just for prosecutors, but for judges, investigators, and even defense attorneys. Once a key witness confirms internal processes under oath, ambiguity collapses. And ambiguity is the defense's greatest ally. Without it, cases narrow, and narrow cases move faster. At this stage, there were only 3 realistic legal paths left. First, a negotiated resolution. This would involve limited admissions, carefully structured agreements, and an attempt to control narrative damage. But this path requires timing and leverage. Melania moved early, others didn't. That imbalance matters. The second path, partial indictments. In this scenario, prosecutors charge peripheral figures first: accountants, executives, intermediaries. This creates pressure upward. Cooperation cascades, evidence multiplies. This strategy has one purpose: break the silence. And it works more often than not. The third path is the most aggressive, and the one prosecutors reportedly began preparing for: comprehensive indictments. These are rare. They require overwhelming evidence and airtight construction. They also signal absolute confidence. Sources suggest this option was now firmly on the table. What pushed it there wasn't public outrage or political pressure. It was alignment. Documents aligned with testimony. Testimony aligned with timelines. Timelines aligned with benefit. That alignment is what prosecutors wait for, because once it exists, delay only benefits the defense. Another quiet development added to the gravity. Financial institutions began internal compliance reviews, not because they were accused, but because exposure proximity matters. Banks don't wait for indictments. They move when risk becomes reputational. That alone tells you how seriously the system was taking this. Meanwhile, Trump's political operation faced a parallel crisis. Fundraising slowed. Major donors hesitated, not out of fear, but calculation. Donors understand momentum, and momentum was no longer on Trump's side. Advisors began debating a dangerous question: can political pressure still influence legal outcomes? In past eras, the answer might have been yes. In this era, less so, because prosecutors had done something deliberate. They removed spectacle: no leaks, no dramatic arrests, no inflammatory language, just procedure. Procedure is immune to rallies. And that's why the Marshals' presence mattered more than it appeared. It wasn't intimidation, it was insulation, shielding witnesses, evidence, and process from disruption. The system was closing ranks. Another layer emerged when analysts began discussing post-indictment consequences, even before indictments were announced. Civil exposure, asset freezes, corporate dissolutions, licensing reviews. Criminal cases don't exist in isolation. They ripple, and those ripples had begun. The most telling sign came late in the week when legal commentators noticed a shift in defense posture. Trump's attorneys stopped attacking the legitimacy of the investigation and began questioning jurisdiction and technical thresholds. That's not a coincidence. That's what lawyers do when the facts are no longer friendly. You stop arguing innocence. You start arguing limits. Limits are the last refuge. At the same time, Melania disappeared from public view entirely. No statements, no appearances, no signals. That silence wasn't avoidance. It was compliance. Once cooperation begins, visibility becomes liability, and the system rewards discipline. One former prosecutor explained it bluntly: the best cooperating witnesses are the ones you never hear from again. That's how you know the deal is holding. By now, speculation had turned to politics again, not as a shield, but as fallout. What would this mean for Trump's future? Could a campaign continue under indictment? Legally, yes. Practically, uncertain. Because indictments don't just constrain movement, they constrain messaging. Every speech becomes discoverable. Every claim risks contradiction. Every denial risks perjury. That's not a campaign environment. That's a minefield. And campaigns hate minefields. Strategists began quietly exploring contingency plans. Not alternatives, but insulation. How to preserve influence even if personal exposure increases. That conversation alone signals acceptance. Acceptance that the legal process would continue regardless of political theater. By Sunday night, one conclusion dominated expert analysis. This case had crossed the point of reversal, not because of one testimony, but because of what that testimony unlocked. Speed, clarity, confidence. Those are the ingredients prosecutors need. The Marshals didn't move in because of danger. They moved in because the system decided this was going all the way. And systems don't change their minds easily. What happens next won't be loud. It won't be theatrical. It will be filings, hearings, motions, and rulings. The kind of process that doesn't trend on social media, but reshapes lives. And when the next development breaks, it won't feel sudden. It will feel inevitable. Because in retrospect, this was the moment everything aligned. The moment testimony became trajectory. The moment defense became reaction. And the moment Washington realized this wasn't about politics anymore. It was about consequence. By the time Monday arrived, Washington had stopped asking what if. The only question left was when. Inside the Justice Department, the pace was deliberate but unmistakable. Prosecutors weren't rushing. They were sequencing. That distinction matters. Rushed cases collapse. Sequenced cases endure. Every filing, every witness, every motion was being placed like a chess piece several moves ahead. Because once indictments are filed, there is no rewind, and everyone in the system knew that threshold was close. What most people misunderstand about high-profile indictments is that the decision is rarely dramatic. There's no shouting, no last-minute revelation. It's quiet, procedural, almost boring. That's how you know it's real. One former federal judge described it this way. When prosecutors stop leaking emotion and start leaking logistics, the decision is already made. And logistics were everywhere. Court calendars quietly adjusted. Judges cleared future windows. Security coordination increased. None of it announced. All of it visible to people who know how to look.